volume 3, we are still in 3, one of those last cases in volume 3, pages 1254 to 1258. They explained at length what agency is for purposes of illegal practices. In that case, my lord, were dealing with bribery as well, and they found bribery had been committed. But they told you the lengths at which agency can go. We invite your lordship to critically look at that decision to guide the court on the issue of agency extensively. The page is 1254, my lord, to 1258. That's where the holding is. 1254 to 1258, my lord. We have highlighted on the side because the authority was the explanation was too long. Now, let me finish the issue of agency, my lord, with this decision. Odo Taiwa versus Masaja Bala Vanasa and EC. Also on agency. Odo Taiwa versus Masaja Bala Vanasa and EC. My lord, I think then we have moved to volume 4. The page is 1295. 1295. Volume 4. The point in the case, my lord, is there is, similar when my colleagues were cross-examining my witnesses, they just said, I am aware Nalukoola was there. Did you see him there? There is, so my lord, as well as an agent of the first respondent, my lord, that decision tells you that there is no hard and fast rule. There is no hard and fast rule as a determination of what agency is for these purposes. What the court looks at, my lord, is the circumstances of each case. And my lord, I must also emphasize and underscore that agency for purposes of bribery need not be and does not have to be that of a polling agent. I had my colleagues cross-examine that bit as well. Polling agents and agency that I'm talking about are different things. Of course, if a polling agent commits bribery, it is very straightforward. But in other cases, my lord, these decisions I'm referring to have explained how we establish agents. In the circumstances of this case we are dealing with the agency that is political. Agency that is political, where the first respondent, the leaders of his party, the functionaries of his party, actively participated in his campaign and election and bribery for and on his behalf. Now, my lord, of course, once agency is proved, the knowledge and consent is imputed. Because there is no time, my lord, when a principal doesn't know what his agent is doing. That's the case of Courtroom that I've given you, my lord. It is on that point. Once I prove that you are my agent, then knowledge and consent is imputed. That you knew what the agent was doing. My lord, we retire and look at that decision at length. And my lord, as again presentation was going on, my colleagues sought to find out whether whether he was his agent. Where of that agency. My lord, in the case I have just referred you to of Nani Gopal Swami, that is again that I have just referred you to, my lord. It was held that direct evidence of consent by the candidate to the corrupt practice done by his agent. I repeat that, my lord. It was held in that case that direct evidence of consent of the candidate to a corrupt act done by his agent in most cases may not be available for obvious reasons. For example, my lord, you will not find that my colleagues were cross-examining Nalukoola telling Alleging, I'm giving you 1 million shillings. Go and bribe Maung. Go and bribe Wamukubira. This case is telling you that evidence is always not available. And it says, and it is unwise to look for it because you don't find it. Okay? That's why I'm telling you, my lord, that once I prove agency, then knowledge of the candidate is imputed, my lord. Now, let me also make a general comment. Now, I'm going to make a couple of legal points, comments on legal points on the various issues about bribery that I saw came up during cross-examination. Let me begin with the first one, like 3 or 4 points, legal points, and then the next legal practice. Let me begin with the first one, my lord. Chamber, Nathan Mwangzi, and Mawumbe 20 million. The bribery of these people by Ben Mukasantale. My lord, I have already stated, and we all know that Ben Mukasantale approached these people for purposes of recanting the evidence for the petition. And the question then comes is, Ben Mukasantale, who I've already said is an agent of the first respondent, what was his motivation? What was he fearing about this evidence? And my lord, Ben Mukasantale did not stop at only approaching these people. As it became apparent from the stand, my lord, these people were taken to counsel for the first respondent. And they did what they did. I don't want to repeat that. The question is, what were they? I mean, the first respondent was aware all that was happening. Okay, Mukasa went and brought this people to the lawyers, they did the affidavits, filed them, blah, blah, blah. So the question is, what were they fearing about Mawumbe and the chamber? My lord, in the case of Chitu Alex Brandon versus EC and another, that same issue came up. And I'm glad my colleague who argued is here. That same issue came up. Why were you approaching? What were you fearing? My lord, their lordships in the Court of Appeal had this to say. Permit me to read it, my lord, at page 394. First volume, 394. In our first volume, my lord, at page 394. Permit me to read it, my lord. You can read it. There, my lord, their lordship said in the Court of Appeal, the brazen and egregious breach of the rules by the second respondent and his legal team, who ought to have known better, was an outrageous attempt to destroy the evidence that pointed directly to the second respondent's commission of an illegal practice during the campaigns. The motivation is clear.
Not today. Counsel appears to be citing authorities on evidence that was expunged from the record. And unless it is evidence now from the back. What exactly?
No, my lord, I think the misconception is from Uganda's part is there is evidence that the evidence I'm referring to, by the way, is evidence they gave at the stand when they were here, when they were being cross-examined. That evidence is the one I'm referring to. I'm not referring to recanting affidavits. No, the one they gave on the stand. Yes, and the evidence they gave during cross-examination. That's what I'm referring to. So my lord, I was reading for you the decision that the brazen and egregious breach of the rules by both the second respondent and his legal team, who ought to have known better, was an outrageous attempt to destroy the evidence that pointed directly to the second respondent's commission of an illegal practice. The motivation was clear. The second respondent knew what was alleged, he had done was true, and in concert with his legal team, set out by hook or crook to neutralize the same. Okay? So, my lord, I'm saying in that case that once you have a situation like this, it is more probable than not, balance of probabilities, okay, that what pushed these people to approach Mawumbe and to approach Chamber is because they knew they had committed an illegal practice. My lord will retire and look at that. That conduct that they put on the record in the examination here is what I'm referring to. I invite my lord to look at that decision and follow the same as so it is on all fours with what we are dealing with. Which now brings me to another point that came up during cross-examination about witnesses on the issue of bribery and all other. And my lord, these points I'm making now, I will not repeat them for other legal practices. I'll just adopt my submissions on this. What also came up was, did you report to police? Did you report to the EC? And the majority of the witnesses said no, they didn't. It is my submission, my lord, that it is not a legal requirement. Okay, that for the offense or for the illegal practice to be proved, a report to EC or to police need be produced. My lord, the statute, the PEA, does not make complaining either to EC or to police an ingredient of any of these illegal practices that we pleaded. Permit me, my lord, to refer you to the decision of Jane Babili Zaninka versus Michael Kigabu. Jane Babili Zaninka versus Michael Kigabu. It is on the holding, my lord, is at page 1348. That's volume 4. 1348, my lord. My lord, there it was held at that page. You will see it, my lord, when you go there. It was held that it's not necessary for a witness to produce a police report to prove an act of bribery. It is not essential. It is not necessary. Further, it was held in that matter, your lordship, that courts have to be very careful in requiring cogent evidence. They should be very careful not to be understood that it is impossible to prove the offense of bribery. That's what the lordship said in the Court of Appeal in that matter. So, my lord, the issue that came up of complain, the Court of Appeal has told us that is not an essential ingredient of the legal practice. Again, my lord, on that, I don't think I want to take you back, but maybe my lord may quote page 444 of the first volume. You will find something else related to that in the case of Atan Moses Okia versus Ariko Habat. You find something related to that, but my lord may not go back to that volume. You may just quote page 444 of the first volume of our authorities. There, my lord, the lordships again in the Court of Appeal, this was about intimidation, the illegal practice of intimidation. There, my lord, the lordship said that it is not essential. It is not essential for proof of intimidation that a report must be made to the authorities. It's not essential. It's not an ingredient. Yes, maybe it is preferable. Maybe it can make you sound better, but clearly it is not essential. It's not an ingredient of any of those legal practices. And my lord, I must mention that those decisions I've given you are 2021 and 2023, because I'm sure you'll find all the decisions. It says, oh, bring a police report, oh, bring this. My lord, the two decisions I've given you, Zanika is 2021, and Tanokia is 2023 of the Court of Appeal, decided last year. And they are saying those reports are not essential. 2024, yes. Atan was decided in 2024 by the Court of Appeal. The other point that came up, my lord, in presentation about these legal practices was, you are the only one who saw. You are the only one who did this. Who bring another one? Bring another person. That issue came up, my lord. It is our submission, my lord, that no number of witnesses is required to prove an illegal practice. Even one witness can prove an illegal practice. It is not a requirement of the statute that for me to prove bribery, I must bring 10 people. For me to prove campaigning, I must prove 10 people. No. The Court of Appeal has said even one person, if he is credible, can prove an illegal practice. I refer your lordship to the decision of Chifu Faizo versus Mwanga Chivumbi. Chifu Faizo versus Mwanga Chivumbi. My lord, the holding in that case that we are referring to is at page 1389 of our fourth volume of authorities. 1389. There, it was bribery again, my lord, in that case. Bribery was held, have happened, the Court of Appeal upheld it, and was in the evidence of a single witness. Okay, so my lord, again, I can provide good guidance on that issue. No numerable number is required. One, if it's credible, is enough. Lastly, the legal point again that came up on these legal practices was the issue of corroboration. Corroboration. So submission, my lord, that it's not requirement of the PEA that evidence of illegal practices must be corroborated. It's not a requirement. As you are aware, my lord, corroboration is always a requirement of a statute. The law will tell you that when on that offense you need corroboration. And this appears, I believe, in many sections of the penal code, for example. That on that one, corroborate, on that one, corroborate. Here in the PEA, that requirement is not there. So, my lord, where my colleagues were examining my witnesses about corroboration, it's not a requirement of the PEA, and their lordships in the Court of Appeal in 2 decisions have said it is not necessary. It's not essential, my lord. First, the petition of Odotaewa versus Gordon Arinda. Odotaewa versus Gordon Arinda. The holding is at page 1448. 1448. Volume 4, my lord. That decision referred to and applied an earlier Court of Appeal decision in Aligawesa Philip versus Biandala James and another Court of Appeal 2011. My lord, there, in both of those decisions, the Court of Appeal said what I'm saying, that corroboration is not essential, it's not a requirement for proof of illegal practices under the Parliamentary Elections Act. Now, my lord, those being the views that we hold. Yeah, one. The second one is Aligawesa Philip. Aligawesa Philip versus Biandala Abraham James. Aligawesa Philip. Aligawesa is on page 1467 to 1468. That's where the holding is. 1467, 1468. Fourth volume. Yes, my lord, I was saying that those being the views we hold on the law and evidence on the illegal practice of bribery, we again invite you, my lord, to find out hold that the first respondent was guilty of the illegal practice of bribery, and for that reason only, the lordship allowed the election. I move on, my lord. The next illegal practice. The next illegal practice is campaigning, my lord. My lord, this incident, like bribery, we are complaining about 4 particular incidents. And I'll review the evidence again, and my lord refer you to the law. Campaigning on polling day, my lord. The first incident is campaigning at Mbogo Primary School Playground. Mbogo Primary School Playground, KATMAJ polling station. Mbogo Primary School Playground, KATMAJ polling station. My lord, there in summary, the petitioner brought the evidence of Gordon Salim Saleh. That evidence, my lord, appears on pages 1203, 1206 of the petition. Because, my lord, I need to refer you. Of course, the petitioner herself. They gave evidence that the first respondent came to this polling station and he's the only one for that. Gordon Salim Saleh, who was the petitioner's agent at that polling station. He says the first respondent came at around 3 p.m., told the voters who had queued up to vote that people power, our power, Yenzen Nalukoola. Those they translated as, it is me, Nalukoola. My lord, what did the first respondent say? He half-heartedly put forth a denial, bare denial here, in his affidavit in support of the answer, paragraph 10A to be specific. Paragraph 10A. He simply said, I did not campaign at that polling station. Bare denial. I did not campaign at that polling station. What he doesn't say in that affidavit, though, he doesn't deny being there. He doesn't say I wasn't there. He simply said, I did not campaign. As to whether he was there, he kept quiet. On his cross-examination here, my lord, He said after voting, he moved around the constituency. He submits that it's more probable than not that he was at this particular polling station. The second one, campaigning, my lord, at Kazo Angola. I refer to the law later. My lord, first deal with evidence. Kazo Angola, Carl to KZ at LC1 polling station. Here, the petitioner brought the evidence of Niwamanya Salva. Niwamanya Salva, who came here for cross-examination, and the evidence of Kalenzi Medi. Kalenzi Medi was an ordinary voter and was the petitioner's agent at this station. Kalenzi Medi was an ordinary voter who had turned up to vote. My lord, they stated that when the first respondent came to the polling station, he said, Amani government, the people who had queued up to vote. Loosely translated as, don't betray people power. In paragraph 10b of the first respondent's affidavit in support of his answer to the petition, two things are clear, my lord, from that paragraph. 10b of the answer, of the affidavit, my lord, sorry. The affidavit in support of the answer. One, he also did not deny being at that polling station. It's not any of that. He simply says, I did not campaign at that polling station. My lord, specific words were alleged to have been uttered. Specific words were alleged to have been uttered by the first respondent at this polling station. He doesn't deny them. He doesn't deny them. He simply says, I did not campaign at that polling station. Again, my lord, during his cross-examination, he said he moved around the constituency after voting. He moved around. And something striking, my lord, came out of his cross-examination. When I asked him, my lord, to translate for me, it's not prohibited, my lord. It's not prohibited, but the point I'm making, that when he says he doesn't deny being at the station, and he says, I moved around, okay, on a balance of probabilities, okay, it is more probable than not that he was at that polling station. And my lord, when I was telling him, I asked him the same what I asked him. And the law allowed him to move around, and the moving is not the problem. Being at the polling station at the particular time we are alleging he was there, and uttering the words we are saying is the problem. Moving is not a problem, my lord. I was saying, my lord, that during this cross-examination here, when I asked him to translate for me the slogan, people power, our power, he said people power means Amani government. What a coincidence, my lord, that Niwamanya Salva had the same words from the first respondent. And when he here came here, translated the same word, he used the same exact words that I had that appeared in his cross-examination. What a coincidence, my lord. Campaigning at Bright Sparks, the third incident. Bright Sparks, junior school, end polling station. Here the person who Bright Sparks Junior School, end-to-end polling station. There, my lord, the evidence of the petitioner. No, there he didn't go. He was at the other two polling stations. But here, the evidence of the petitioner, first, my lord, is from Jenny Nansamba and Courtroom. Their allegation, their evidence is that at this polling station, Naba Kozarita, who have been talking about in bribery. Naba Kozarita, together with the chairman of that area, LC1, they stood at the entrance of the polling center and told Nansamba Jane to vote for the first respondent. My lord, Nansamba Jane came here for cross-examination, and I think she was one of my firmest witnesses. Completely unimpeached, my lord. She remained firm. She remained very firm that Naba Kozarita told her to vote for the first respondent at this polling station. Now, Naba Kozarita, my lord, made an affidavit made an affidavit, and again, just like the first respondent, gave us only a bare denial. Bare. But what is striking, my lord, in that affidavit of hers, paragraph 5 to be specific, she does not deny being at that polling station that day at that particular time that Jane is saying she was. In her affidavit, she doesn't say I wasn't there. Moreover, in her cross-examination, my lord, she was asked about her observer role and whether she was at this polling station, and she conceded that she was in her cross-examination. Kochibilige Musa, the chairman of the area, he also made an affidavit, my lord, and saying after voting, gave a very feeble account of where he went after voting. Our evidence that he remained there with Nalukoola and they campaigned. For him, says, after voting, I went to do the duties, the normal duties of my role in that area. What duties, where he went, he does not say. Lastly, my lord, campaigning at Equatoria Kindergarten, N to Z polling station. Equatoria Kindergarten, N to Z polling station. There, my lord, the evidence of the petitioner is contained in the two affidavits of Mike Mulindwa. Mike Mulindwa, the first one is with the petition, and the second one, my lord, is in the second bundle that we filed on the 29th.
Who's the second person?
It's the only one, my lord, but has two affidavits. Yes, it has two affidavits. There, my lord, he says that the polling agent of the first respondent, Damba Kezekia, campaigned among voters who queued up to vote by telling them, Uronde Umbrella, he also held up, according to Mike Mulindwa, he held up the umbrella, which is the political symbol of the National Unity Platform. My lord, here, the distinction with the other three, with the previous incident, is that here we are talking about a polling agent. So the issue of agency is not in dispute. Of course, the first respondent in his affidavit answered the petition. Interestingly, paragraph 10C, he first denies Damba Kezekia. He says, I don't know those people you're talking about who you allege to have campaigned. 10C, my lord. But his cross-examination here, he conceded that Damba Kezekia was his polling agent at this polling station. On his part, Damba Kezekia took us into one of the greatest lies of this petition when he told us that, look, yes, I was the polling agent, first of all. 2, yes, I was at that polling station. Second, 3, yes, there were umbrellas at that polling station. But he says, there were black umbrellas and there were 3. That's the version he gives us. Black umbrellas and there were 3. And what does he say? He says these umbrellas were at the nearby polling station of Mulindwa. And because we wanted to protect our BVVK on our station, we asked the presiding officers at the other station to give us 1 umbrella. Such a lie. Why? If presiding officers at the other polling station had 3 umbrellas, supposedly to protect the BVVK, why did this polling station have 1? 2, why did this man take it upon himself to ask for the umbrella on the other station? Why not the presiding officers? 3, who told him that the BVVK needed an umbrella to protect something the presiding officers did not know? Blah, blah, blah. My lord, that story is as follows. It is a lie. It is a poor turn at the version of events as they were on that day. If the EC knew that BVVKs need umbrellas to protect, clearly they would have provided those umbrellas at every polling station. Now, my lord, on the law now, I'll begin with Order 6 Rule 8 of the CPR. Order 6 Rule 8 and Order 8 Rule 3. They are about the same thing. Order 6 Rule 8 of the CPR and Order 8 Rule 3. They are about the same thing of bare denials. Don't deny barely. We know the burden is not yours. Give a reasonable explanation. You can't simply say, when they tell you that your polling agent campaign, you first say, I don't know him. Then you come here and say, I know him, and you stop there. No. My Lord, in the case of Tubo Christine Nankwang. Tubo Christine Nankwang. Court of Appeal versus Akelo Lily Rose. That kind of pleading, that kind of answer was dismissed by the Court of Appeal. The page is 1517, my Lord, in the fourth band of authorities. 1517. The respondent there had been accused of bribery, and he gave us these kinds of answers. I did bribe. I did go there. I did campaign. The lordships in the Court of Appeal say those that they had denials and are unacceptable. You will see the holding, my Lord, at page 1517. My Lord, I'll give you 2 examples of authorities where the election has been annulled for campaigning. I'll give you 2 examples. My Lord, I was going to give you 2 examples of cases where the election was annulled for campaigning on election day. The first one, I referred to it earlier, Bantali v. Satali Gola. Bantali v. Satali Gola versus EC. My Lord, you may probably just quote the page. I don't want to take you back to the second volume. Page 826 to 827. 826 to 827. My Lord, there the election was annulled for campaigning on election day. The other example I'd like to give you, my Lord, is Nambo's Ebet Bachileke. Nambo's Ebet Bachileke versus Bakalua Peter. Several incidents at the High Court, my Lord. EP number 14 of 20. The page numbers, my Lord, is 1569. No, 1569, my Lord. Yes, to 1573. To 1573. About 4 pages, my Lord. We highlighted them. And there, my Lord, the judge considered various aspects, various incidents of campaigning, and gave guidance on how you treat these incidents and what kind of evidence you bring, which you have brought in this matter. Like I said, my Lord, I will not repeat the submissions on the law to do with corroboration, with agency, with number of witnesses. That, my Lord, I have already submitted under bribery. I adopt those submissions, my Lord, with regard to this legal practice as well. Number of witnesses, corroboration, agency, I have already explained that to my Lord, and I adopt those submissions as far as this legal practice is concerned. Okay, my Lord, that's page 826. Let's go. Yes. That's the volume, second volume, my Lord. Eight to 7. My Lord, you can go to pages 826 and 827, paragraphs 98 and 100. In 98, my Lord, respondent number 2 generally denied the above allegations, just like the first respondent has done here in his affidavit in reply and supporting affidavits. From the evidence adduced by the petitioner, which we have brought also, my Lord, I am satisfied that respondent number 1 illegally moved with armed policemen and canvassed for votes at Manga LC1 polling station. Then paragraph 100, I have found that respondent number 2 committed the illegal practice of moving around with an armed officer within the Prince of Sale polling station on the polling day, and the next sentence is what I'm interested in, and canvassed for votes at the same in those polling stations. The illegal act is sufficient justification to annul the election. The other one, my Lord, is huge. Yes, my Lord. Yeah, 15, volume 4. 1569, 1573. My Lord, there the judge dealt with so many incidents of campaigning. 1569. First of all, my Lord, if I take you on that very page, I've been making the argument about bare denials. If you see the last paragraph, court refused the respondent's answer for bare denial. Actually, throughout, my Lord, all these incidents, the court refused bare denials. I don't know if I should go through, my Lord, every incident. There are so many.
No, that's the point you were making. You were making point about
yes, the point.
So, the point about general denial, what is the part of campaign?
Let me just go over, my Lord. Just give me a minute. My Lord, if you go 1570, the second paragraph, in that issue, the judge was dealing with campaigning on polling day. Next paragraph, my Lord. Next page, sorry, my Lord, also 1571, the second paragraph. My Lord, the second paragraph. It says, in reply, one of the respondent's agents, police station deponed that it's not true that the first responsible acts of campaigning, said police station. Court finds this a general denial, it's not an independent witness. Yes, my Lord, but that incident was on polling day, that very one. Even the next one of Kayongo Christopher was on polling day, the next page, 15171, second paragraph. He was surveying, just like Wongoya was doing. This Kayongo Christopher was the one surveying on that day, on the election, on polling day, my Lord. If you see paragraph, the second sentence on that paragraph is polling day. The second sentence on that paragraph, my Lord. So, and on and on and on. There are many incidents, my Lord, that the judge was dealing with. So, I was just trying to give you examples, my Lord, of cases where elections have been annulled for campaigning. My Lord, on the force of those authorities and with that evaluation of evidence, for the third time, I invite your Lordship to find and hold the first respondent was guilty of the offense of campaigning on the day of the election. My Lord, I need to take a rest. My colleague Chigula Mahi Mahmoud will talk over from there. The last two, obstruction of voters and obstruction of election officials, and I'll come back, my Lord, and sum up. I'm obliged, my Lord.
For the record, my lord, my name is Chibula Mahiri Mpamu. My lord, on those links, I'm going to take you on obstruction of voters, and then obstruction of voting, obstruction of election officials. But my lord, first, I'm going to take you through obstruction of voters. My lord, in obstruction of voters, we have identified 2 polling stations. My lord, I'm going to take you first on obstruction of voters at polling station of Kalanda's compound A to M. Then the next is Kalanda's compound N to M. The next N to N. N to N. The first one is A to M. Yes, my lord. Then the next is N to N.
So there are 2 stations.
Yes, my lord. My lord, I will first deal with A to M. My lord, on A to M, the petitioner brought the evidence of Kagumba Wilson. Evidence of Kagumba Wilson. My lord, his affidavit is on the second bunch which we filed, and it can be found at page 1 to 53 of the second bundle we filed. My lord, 1 to 53 of the second bunch of affidavits we filed. My lord, in his affidavit, Kagumba explains that the polling agents of the first respondent, to wit, Cheswa John David and Semuju Hakim at that polling station obstructed him to vote. My lord, on his affidavit, you have attached that actually Kagumba Wilson is a voter at that polling station. We have also attached a DRA form appearing at page 53 and 54 on his affidavit, indicating the names of those polling agents of the first respondents. My lord, interestingly, this evidence has not been rebutted by the first respondent, neither in his answer or affidavit in support of his answer to the petition, or any other witness brought by way of affidavit to rebut this evidence. My lord, for that alone, I wish to take you to the authority. Then I wish to explain to you that then what happens to that unrebutted evidence? What is the position of the law? My lord, I wish to take you to the authority of Attorney Okia Moses versus an EC versus Ariko Herbert, EPA number 7 and 10 of 2021. My lord, it is at page 954 of the second band. We had already, my lord, referred you to that page. Volume 3, my lord. My lord, if you permit me, I can clearly read that. Yes. Their lordship, my lord, said that this argument had not been controverted or even rebutted by any evidence or in cross-examination. Therefore, the settled position of the law is that such evidence is deemed to be admitted. It was therefore more probable than not that the respondent would have garnered those votes. My lord, having not rebutted that evidence, it is our submission that that evidence is not challenged, and therefore it is true. Like, what did the first respondent did while replying to that? In disguise. In disguise. My Lord, we'll see paragraph 11 of his affidavit in support of the answer. He does not say that he doesn't know those people. It is therefore telling that a charge of obstructing voters is being proved. My Lord, I want to interest you in the authority of Kampala Capital City Authority versus Fuelex Uganda Limited. High Court, Miscellaneous Application Number 62 of 2023. My Lord, it is at page 1648 to 1649 of our Band of Authorities, Volume 3, Volume 4. My Lord, in that case, the land judge referred to the Court of Appeal Authority of Serafako Consultants Limited versus Euro Consult BV and another civil application number 16 of 2007. My Lord, the Court of Appeal, my Lord, it was held that the Court of Appeal stated that it is settled law that if the applicant supports his application by affidavit or other evidence, and the respondent does not reply by affidavit or otherwise, and the supporting evidence is credible in itself, the fact stands unchallenged. My Lord, now, the one golden question before court is what amounts to obstruction of voters. My Lord, also permit me, in order to bring out the ingredients of this offense, to take you to the authority of Amonging Jane Francis, Amonging Jane Francis versus Lucy Akero, EP number 1 of 2014. My Lord, it is at page 1671, volume 4 of our authorities. My Lord, it was held there that in order to succeed on the offense of obstruction of voters, the petitioner would have to prove by way of affidavit. The affidavit is there, my Lord, showing that on polling day, voters appearing on the voters register were obstructed from voting by the respondent's agents, naming specific polling stations, officers or agents, or who obstructed voters from exercising their constitutional rights, how they were obstructed, and what time they were obstructed. My Lord, for instance, in that affidavit, we have demonstrated of Kagomba Wilson that he is a registered voter. He went to vote at about 1 p.m. The polling agents of the first respondent, Cheswa John David and Semdu Hakim, at that polling station, who were his agents, my Lord, we have attached the DRR forms to show that those were the first respondent's agents, obstructed him or refused him to vote by saying that they should first check his verification, by objecting to checking and verification of his name on voters' roll. As a result, my Lord, that witness did not vote. My lord, now the question is, was that voter's right infringed when he was denied to vote by the first respondent agent? It is our submission, my lord, before you that yes, his right was violated. And then what will happen if that right is violated? Then what happens? My lord, I want to persuade you with the Supreme Court Authority of India. It dealt with the issue before court now. That is the authority of Janak Sinha. My lord, it is at page 1745 to 1746. Yes, of volume 4 of Band of Authorities. My lord, if you permit me, I can read verbally. When a voter is prevented from exercising his vote by the supporters of the candidate and in his presence and without any attempt made by the latter to stop his supporters from so doing, the only inference is that the voter was prevented from voting by the supporters of the appellant with the latter's consent. If that is so, it follows that there has been a direct inference with the free exercise of his electoral right. At this instance, at this one instance alone, my lord, clearly established that the appellant has committed the corrupt practice of undue influence. Here, it is obstruction. In India, that's how they call it. It follows that it must be held that this election has to be set aside on this ground alone. My lord, the evidence is before court that this witness before you was obstructed from voting by the agents of the first respondent. That evidence has not been controverted, that evidence has not been denied, and that evidence, my lord, is before court. My lord, we repeat our submissions on various aspects of agency, corroboration, and number of witnesses, also in this particular offense. And my lord, we invite you to hold and find that the first respondent is guilty of the offense of obstruction of voters at Kalanda's compound A to M. My lord, now I can go to obstruction of voters at Kalanda's compound N to N. N to N. My lord, on this ground, the petitioner brought various affidavits of Nasanga Deborah at Nasanga Deborah. My lord, this affidavit is at page 1260 to 1261 of the petition. An affidavit of Babile Sherina at page 1256, 1259, and the affidavit of Yiga Hakim appearing at page 54 to 56 of the second bundle of our affidavits filed in my report. My lord, all those witnesses in all their affidavits state one common thing. That is, they were obstructed from voting. My Lord, they name the agents of the first respondent as Bukenya Bone, Honorable Valimwezo Ronald Kisubuga, Serunjogi Edward, Sempija Joseph, Sam Kasige, Auma Scovia, and Chibirango Fred. These are the agents of the first respondent who obstructed those people, my Lord, before you. And there is no affidavit evidence. There is no affidavit evidence from these people. Therefore, it leaves only one room that this evidence is correct. Why? They have not challenged this evidence. There is no affidavit against this evidence in court, either by these people who are named as the obstructors. My Lord, you have attached evidence that all these witnesses who saw an affidavit showing that they are obstructed from voting are registered voters. My Lord, you have attached the voters' roll to that effect. My Lord, on that alone, it is our submission that you be pleased to find that this offense of obstruction of voters at that polling station is proved. My Lord, now I can go to obstruction of election officials. My Lord, this obstruction happened at various polling stations, but I want to point out one polling station, Kazo Angola, NAC Kunamas. Kazo Angola, NAC NAKK Kunamas, NAMAS, at Bossas Road polling station. My Lord, the petitioner has that the first respondents agents and campaigners, Ewan Julius Mutebi, Matthias Warukaga, and Honorable Chiaka Hillary, aka Dr. Hildeman, obstructed election officials. My Lord, it is also the evidence that Ewan Lewis Rubongoya, the Secretary General of the National Unity Platform, also attempted to forcefully enter that polling station. My Lord, in his evidence before you, he doesn't deny that actually he was around the electoral area for and on behalf of the first respondent. My Lord, in that evidence, these people were taken away by the police. This evidence has not been controverted also. Why? All of them have been placed at the polling stations. My Lord, in response to in a vague response to that, the first respondent repeats his vague and bare denials to those allegations. My Lord, we now submit that it is not fatal that the names of the polling officials were not specified, for the reason that all parties agree that officials were there and voting took place. Why? My lord, during cross-examination, the witnesses were pressed to actually say that whether those were election officials who were rotating around those polling stations. Of course, they are not. But it is an evidence of a one Lewis Luwongoya that actually he was rotating around those voting stations. Therefore, he never denied that he was there, and all this evidence against him is not rebutted. My lord, it is also strange that throughout his affidavit evidence, the only thing he denies is the offense of obstruction of election officials. It is very strange. We therefore, my lord, on the balance of probabilities, it is a submission that the offense of obstruction of election officials has been proved. We so pray, my lord.
My lord, I have now rested a bit, and I want to wind up now. Before I do so, by really briefly speaking about the remedies, really briefly. My lord had given 3 tasks to my team here in the course of my submission on the first one. The second issue. The first one was to confirm, my lord, from the voters' rolls, if the number of 16,640 as appears in the tally sheet is the same number on the voters' roll. My lord, we were able to confirm that the number is the same. If you go to the voters' roll, on top of each one of them, that's the annexures D1 to D14. To the affidavit in support of the petition, you will find those 14 voters' rolls for the 14 annexures D1 to D14, my lord. And you will see, my lord, that on top of each voters' roll, there is a registered number of voters. Yes, the cover page. So you will see, my lord, on top of each page. If you add all of them, yes, my lord.
It's the 1436.
Yes, I go there. Yes, my lord.
1436.
Yes.
If you add
Throughout,
you
you will get 16,640. We have confirmed that through calculation.
The other way of getting the number
Is on the tally sheet. On the tally sheet, my lord.
which
It is
the last page.
annexure B, no, my lord, annexure B, the affidavit in support of the petition.
Yes. And then
If you go there, my lord,
where?
on the tally sheet,
Yes. Where?
there are columns, my lord, the third column. It gives you registered voters. Column 1 has parish, the next one has the station, the third one has registered voters.
Yes.
If you look through, my lord, at all stations which return 00, the number in that column is the same number on the voters' roll. And the summation,
No, you first give me an example.
how can we give you an
Give me an
example?
example, like on which
Let me give you an example. Let's go to page 3 or page 24. Let's use the petitions. Yes, page 24. The polling station is Mbogo Primary School, A to CAS. That, my lord, from top, it is 1, 2. Yes, you see it, my lord, on the tally sheet.
yes.
In the column for registered voters, it's 1436. If you go to D1, my lord, it's at page 45, which is the voters' roll now. I'm taking you to the voters' roll. See, the number is the same. If you go to 1436. You can see.
If you want to add all these, one
So,
is 0%,
well, yes, my lord.
one is 0% return, the other one is.
Yes, my lord. You get that same figure that you needed. Okay. The second issue, my lord, the second thing you asked me, I'll get back to you on, was the decision of Mosuko and how it applies the test of substantiality. My lord, page 702. That's the second volume of our authorities. If I could just take you back there. 70 PS, my lord. Volume 2 is the second volume at page 702.
702.
Yes. Page 702. Now, followed from that second paragraph, the point I was making with this case, Your Lordship, was that if you want to find substantiality, you compare the number of disenfranchised voters vis-a-vis the margin between the first two candidates. My lord, from the reading of that paragraph, that is what the court said happens. That's how you find substantiality. If I could read for you, my lord, there is no doubt that the non-inclusion of the election results of the impugned polling station disenfranchised the voters who turned up to vote, as the trial judge rightly found. So, the issue for this court is to determine the impact, substantially, the impact of the non-inclusion on the final result. Determination of that impact is substantiated, my lord, of the omission extends to ascertaining the number of voters disenfranchised. The number of voters disenfranchised. And whether such number would reduce the winning margin in such a way as to put the victory of the winning candidate in doubt. That is how we find substantiality, my lord. The last issue is to do with the standard of proof. My lord wanted me to tell you if I have a particular case that was dealing with an illegal practice and the standard was held to be on a balance of probabilities. My lord, I refer you back to the decision of Paul Mwiru that I used to explain that issue at page 280 and 281. So in our volume 1, my lord. There, their lordships, after setting out the standard, they are dealing with the issue of bribery. And they say that the standard of proof in election petitions has been set by the Supreme Court in Mukasa Harris versus Dr. Luyimbazi. Now, my lord, I don't have to bring that decision because their lordships in this case referred to it. And they confirmed, in line with that Supreme Court decision, that any ground is proved on a balance of probabilities. Now, they actually criticized the judge on the next page, 281. They criticized the judge for having used a standard higher than balance of probabilities at page 281 to prove bribery. They criticized the judge for using a higher standard from the presidential election petitions of Messiah, that kind of thing. They said, Your Lordship, at page 281, that those decisions were inapplicable. Were inapplicable and the standard is one on a balance. As clarified by the Supreme Court. Finally, my lord, it is our submission from our analysis of the evidence and the authorities we have given and the provisions of the law that we have referred to, that the petitioner has made out a case for annulment of the election of the first respondent. For annulment of the election of the first respondent as Member of Parliament for Kawempe Division North constituency. It is our submission from the evidence we have laid before the court, on the force of the authorities we have given you, my Lord, the provisions of the law we have referred to, that the petitioner has made out a case for the annulment of the election of the first respondent as Member of Parliament for Kawempe North constituency. We therefore invite your Lordship, under issue 4 of the remedies available, that you be pleased, my Lord, to grant all reliefs as set out in the petition. All the reliefs, my Lord, we set out in the petition, we pray that you be pleased to grant them. We so pray, your Lordship, and thank you for your time this morning.
My colleagues are requesting this to be first without being recognized.
Tusinkane nja ku ssaawa 3 mu kifo kye kimu, ensonga ze zimu, baloya be bamu ate ne jjaji y'omu, ku chano y'emu n'omuweereza nga y'omu. Teweerabira data bajja mumpa kulibasanawo agamba banaye koti eddamu nkya obadde ku Shalom Television Uganda. Yes. Enkya Faridah Nalukoola yegenda okwogera. Tomorrow don't miss. Enkya baloya ba Nalukoola bagenda okuwoza.
Kwata omungabidde soko nsituliremu ku kamera yo.
Gundi eno yafudde muno tekyanywera. yamenyese gulaguzi empya.
Bakuwenga omusango tegunnagwa ogule
Ayinza obutampo
Kawempe no one child.
What Wilson polling agent from the construction?
Extreme. Gwanyigiriza amadaala anti balibakosa lift wagatusookayo wadde live ku Shalom Television Uganda. Guno musango genda kwennyonyola. Mwendako mu town mbeko bira byankola mabe. Mwenda kwera na mu regulo. Mwenda kudda live leero mwenda kudda live regulo naka program kengenda ako. So regulo sawa 10 zennyini. Mubeereko ku Shalom Television Uganda mwenda kwera live. Ne wina kile okandaba kumpi okandaba siku walibadde ku lift ne president walibadde ku lift ne president Robert walikola lift naye ne lift yaduuka mangu lift yanyiza ali mu lift wamu ne president ne lift yatuuka mangu naye njagala lift erwewoko kweli